Sir, your attention, please. Any submissions with regard to adjournments will be through first VC, then memos. After the memo submission, if any
page one and next page number. What is
Santosh, sir. So, voice clear idea? Santosh, sir. Deepak. Naresh. Naresh, voice clear idea? Deepak. Sir, Deepak. Santosh, sir, voice clear idea? Santosh, sir. Deepak. Naresh. Voice clear idea? Sam, yes, sir.
It's clear.
Please put on your name, ma'am.
Sure.
BC submission for all.
Mentioning through video in the memos.
This is an appeal of 2019. And in fact, it is an virtually an ex parte decree in the sense we did not contest the proceedings after the stage of the evidence. Resulted out in granting a decree for partition. We are the buyers of some portion of the property which was not the ancestral property. Later, miscellaneous petition was filed to set aside the decree. Unfortunately, that miscellaneous proceedings was with little delay, filed with little delay, which was not accepted by the trial court and concluded the proceedings in dismissing the miscellaneous petition itself. As against which the appeal is filed. Now, the urgency of the matter is now the final decree proceedings, as I have been instructed by the council and record before the trial court, that is drawing to close. Therefore, can it be had tomorrow or on Monday? Because stay is not granted of the final decree.
Yes.
2018 matters, after the respondent in this appeal, I think I would in favor of the decree, right, in my favor. The defendant appellant has filed this, and 3 advocates have been changed. But every time, no objection. But yeah, 190, 199. Then compare for office of the endless of
What is the stage now?
RFA.
What is the stage now? Is it for complaints?
Complaints of non-complaints of office of the stage. City for complaints of office of the.
Are you complying of his objection?
We have not complained.
Whether the appeal is now pending for complaints of office objection, then comply the office objection.
Because time is 15 days we have given this honorable court. Already take more. In February, it was decided matter. For complaints of office objection.
Huh.
We have approached the office on level. Because we have filed NOC of
No. Subsequent to non-compliance, what happened? Whether the file is still pending or is it dismissed? Pending. It will come for non-compliance. If for 2 occasions have not complied, it would come for non-compliance for 2 times. If it is 3 times, it will come for non-compliance 3 times. Yes, keep your wallet ready. Looking at the number of attempts, imposing the cost, time would be granted to you. Yes. Santosha, katti bidi dudu. Yes, next week. Yes, yes, please. What the suit was for? Which year matter?
Nothing for response number 2 in this case, my lord. The appellant has filed. The injection suit was filed before the lower court by the appellant. Now the suit was dismissed in its court below. That order was challenged before this under court. In this case, my lord, we are response number 2. But response number 2 is the contesting party. But he has expired 3/8/2021 itself. I intimate to the court judgment. But so far they have not taken steps with the appellant. The appeal is awaited. But injection was already granted in this case. Interim order was granted. Kindly have it.
Call the cases.
Non-compliance of officer question, second time, say number 1, Sarvana, yes.
The counsel for the appellant who is physically present prays for short accommodation as a final last opportunity. A week's time is granted to comply of this objection, failing which the court may proceed to pass appropriate order, including dismissal. Failed to proceed to pass appropriate order. To comply of this objection, hardly you require 15 seconds. 15 seconds, not even 16 seconds.
Say number 2, Patil, Ramgod, Basangod.
None appear as a final opportunity, 1 week, failing which. So also, in case if office subsection not complied, in a week, list the matter on 9/6.
Say number 3, Hadley, Sushil Kumar, Vikram.
We withdraw the case.
You are withdrawing the case. File a memo. File it right now. Let a memo be signed by the counsel who holds the wakala. It is passed through at the request of the learned counsel for the appellant. File a memo of not passing the appeal as comma as desired by him.
Say number 4, Maheshwarappa. Say number 5, Vipin Hegde.
The request of the learned counsel for the appellant as a final last opportunity, a week's time as paid is granted, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if the office objections are not complied with, registry to list this matter on 13/6. It has 1 week finally.
Say number 6, S. Ramburthy. Say number 7, S. Ramurthy. Say number 8, Irappa Reddy.
Finally, 1 week.
Say number 9, Sridhar Murthy.
Finally, 1 week.
Say number 10, K. Ravi Shankar.
thanks to finally reach them.
Finally, one serial.
Bill number 11, Asal Kumar.
What for the appellant? Either present physically nor video conference. According to registry, the appellant not complied of his objection raised on IA 2/2021. In view of the fact that IA is of the year 2021 till date since the appellant has not complied. One simple office objection and has made the IA pending. Till date, I don't find any reason to further grant any time as such. IA 2/2020 and is returned to the appellant for non-compliance.
Bill number 12, Rico, Arjun Rico.
Finally, one.
Bill number 13, Nandakishore V.
But date 13/6.
Bill number 14, NS Bhatt.
Finally, one.
Bill number 50, Mukannappa SB.
Permit the appellant to withdraw the
Yes, good.
appeal, not present.
For the appellant, who physically present, files a memo seeking withdrawal of this appeal as not passed. In view of the memo supporting submission, the appeal stands dismissed as not passed.
Bill number 16, Sumati S.
Serial 13.
Bill number 17, Srinivas S.
Serial 13.
Bill number 18, Srihari AV.
Serial 5. Finally, one.
Bill number 19, Mohan Rangam. Bill number 20, Gowda GK.
Same order.
Bill number 21, G. Narayan Rao.
Serial 5. Finally, one week.
Serial number 22, Praveen Kumar.
Serial 5. Finally, one week.
Till number 23. Till number 24.
Serial to date 14/6.
Till number 25. Kiran. Till number 26. Syed. Till number 27.
May I please,
Master.
may I please move for the appellant, request the lordship to grant 2 weeks time for complying with the objections.
Finally, 1 week, serial 5/14/6.
Oblige and
Till
grateful.
28. Santosh S. Gogi. Twenty-eight. Till number 29. Harish Kumar. Till number 30.
Serial number 28 and the serial number 24 and 38.
Till number 31. Abhinav Ramanand. Till number 32. Amit M. A. Mandagi.
This number they can put in users. To dismiss is really adjectively.
Take a week time.
Finally, 1 week, serial 27.
Till number 33. Abhinav Ramanand.
Till 27. Finally, 1 week.
Till number 34. Third time. Non-compliance. Gudian.
Update directed me to produce a separate copy of the plan to know the value of the property, since the plaintiff is not mentioned the value of the total value of the properties for the jurisdiction purpose. He mentioned only 50 lakhs. And I produced the separate copy of the plan and make a note regarding that. Suitable properties measuring 7 acres in and around Bangalore city. And I made a property value of the properties around 2 crores 50 lakhs in the as on date of the suit, and share of the plaintiff is 50 lakhs. Valuation client or client is not stated anything regarding the total value of the property.
Have you clarified whether the sum of rupees 50 lakh, which is the valuation made, was the total value of the property or of the plaintiff's share?
I made a submission in the valuation. In the client or valuation slip. It doesn't clarify, doesn't clarify that it is a total value or share. My submission is, my lord, properties measuring 7 acres and some.
How you have understood that?
Said, my lord, it is share of plaintiff.
Clarify the same in the registry.
I mentioned in the valuation
Page.
page. Page 12, my lord. Corrections. Fill in.
What have clarified? The 50 lakh rupees is
Share of the plaintiff.
share of the plaintiff. That counsel for the appellant who is physically present submits that. Client filed in the original suit. Shows the valuation made by the plaintiff. Under rupees 50 lakh. Client counsel submits that since the plaintiff has claimed his share and value, it at rupees 50 lakh, it is the valuation of the share of the plaintiff. He further submits that the same is clarified by him even in his memorandum of appeal. Paragraph number 27. In the light of the above submission, subject to the objections to the such submission of the appellant to be made, if any, by the respondent in the first hearing, in their first appearance on the date of the first hearing of the service of comma, the registry to proceed accepting the said submission of the learned counsel for the appellant that the sum of rupees 50 lakh shown. The valuation slip in the trial court is that of the value of the share of the plaintiff. Yes.
Till number 35, Babu M. Till number 35, Babu M.
None appear for the appellant either physically or through video conference. So no reason for coming to another country. On 5/2002, this court made the following observation. In spite of granting several opportunities of not less than 3 times, it has not compared office objection or even shown any reason other than it is found that in several of the matters where the present counsel for the appellant is a counsel for the appellant, the office objections are not complied in spite of granting sufficient opportunities, thus compelling this court to pause appropriate orders, including dismissal of the appeals. This case is also not an exception to the same. In several cases, ಇದನ್ನು ಕೆಳಗಡೆ shift ಮಾಡಿ ಮೇಲೆ ನಾನ್ ಕಾಂಪ್ಲೈನ್ಸ್ ಆಫ್ ದಿ ಡೈರೆಕ್ಷನ್ ಆಫ್ ಫೈಲಿಂಗ್ affidavit 16(4)(21) non payment of cost imposed on 23(5). Several matters is not appearing. Dismiss for non-prosecution, non-complaints. beneficiary of the cost, LSC, copy to be sent to them.
Cell number 36, Suresha.
Have you complied of his objections?
Except one, your lordship, plain of this, I have to. Modified sign on. Very well.
The counsel for the operant present alleged delayed payment of the cost. Or around 20 to 5 is accepted. The counsel submits that he is required to file the synopsis, which is the only of his objection due for complaints and he will do needful in the 4-1 session of this court.
Personal income.
ಏನ್ ಫಸಲ್ ಇನ್ಕನ್ವೆನ್ಸ್ ರೆಡಿ ಅಂತ ಹೇಳಿದ್ರಿ, ಇಟ್ ಈಸ್ ರೆಡಿ ಮೈ ಲಾರ್ಡ್ ಅಂದ್ರಿ, ಫೈಲ್ ಮಾಡಿ ಮನೆಗೆ ಹೋಗಿ ಅಷ್ಟೇ.
Taking.
ಬಿಟ್ಟಕ್ಕೆ 2,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕಿರೋನು ತಿದ್ಕೊಳ್ಳಿಲ್ಲ. 4 ಸೆಂಟೆನ್ಸಿನ ಸಿನಾಪ್ಸಿಸ್ಗೂ ನಿಮಗೆ ನೀವು 2 ಸತಿ ಓಪನಿಂಗ್ ಸೆಂಟೆನ್ಸ್ ನಲ್ಲಿ ಓನ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಬಿ ಕಂಪ್ಲೀಟ್ ಇಸ್ ಸಿನಾಪ್ಸಿಸ್, ಇಟ್ ಈಸ್ ರೆಡಿ ಅಂದ್ರಿ, ಫೈಲ್ ಮಾಡಿ ಹೋಗಿ. 4-1 session failing which the appeal stands dismissed on its own with effect from 1/6/2023 without any further orders by this court.
Fourth branch, cell number 37, V. Mohan Kumar Kadekar. Cell number 37, Mohan Kadekar.
Appeared for government either physically or through video conference. No reasons are forthcoming for his non-appearance. Result of the after sheet would go to show that in this appeal of the year 2019, in spite of continuing and sufficient opportunities, not less than 4 times, including an ultimate chance, the appellant has not complied with of his objection. Hence, I do not find any reason to grant further time. Accordingly, the appeal stands dismissed as a fall. And prosecution of charges for non-compliant.
38, Govindraj L.
The registry to calculate the 4P, the confusion property 4P. I can find the suit for recovery of security deposit of 6 lakh rupees. The deposit had filed a suit for rejecting. Both the suits were partly allowed. The decree does not speak about my security deposit. So for both suits, the rupees gain profits are clear. That we calculated in separate proceedings.
The counsel for the appellant is physically present and makes some submission in connected with the complaints. Which are already listed on history. The result of the order sheet will show that several insufficient opportunities have already been granted to the appellant. Without this objection, not less than 4 times. The bill is of the year 2019. No complaints of direction. Dated 6/4/2020. Thereafter, the cost was also imposed upon the appellant. The office subjection, though the appellant appears to cover the cost, but the subjections. As I do not find any reason to grant for the time accordingly, the appeal stands dismissed for non-compliance of office subjection.
Serial number 39, Nupama MV.
The counsel for the appellant neither physically nor through video conference, no reasons are forthcoming for non-compliance of office subjection. Twenty-three 5/2023, this court had made the following observation. Even those, in spite of making the above observation, appellant still retained few more office subjections to comply with, and has not complied with the direction. 5/4/2021. Taken, the learned counsel for the appellant directed to file an affidavit explaining the reasons for non-compliance with specific reference to office objection from date of raising of office objections till expiry of further time granted by the court on the said date. In the light of the above, I do not find any reasons to grant further more time. As such, the appeal stands dismissed, not prosecution, as well as for non-compliance of office.
Serial number 40, Murugesh Charity.
Appellant counsel absent to. Dated 23/5/2023 extract to. Reasons for coming back. Inputs not paid. The direction to file affidavit dated 8/4/2021. Not filed, not complied. Affidavit not filed. Dismissal, non-prosecution, non-compliance, copy to LSC beneficiary.
Serial number 41, HR Anand Krishna.
The appellants, madam. The subjections have been complied. Affidavit is filed.
Then why the matter has been listed today?
We have filed it on 25/5, the affidavit and the cost has been paid, my lord. It actually says memo, but an affidavit was asked to be filed in the order 54. The affidavit has been filed. 25/5.
Affidavit was filed with respect to the order of what date?
My lord, it was 15/4, my lord.
15/4.
21.
15/4. Why the matter is listed today?
Lord, Lord, it says the non-filing of compliance memo.
Yes. Is there no difference between affidavit and memo? And was there not a separate direction for you to file a memo?
Lord, for affidavit, we had a direction. Memo, there was direction to file an affidavit. Affidavit,
You are making this court to impose heavy cost with a detailed observation.
we have complied with the objections as well. And the same has been noted in the affidavit. There are 5 objections.
On 23/5/2023, you were directed to file a complaints memo regarding the payment of the cost.
Not cost, they have paid.
ಹೌದ್ರಿ ಕಾಂಪ್ಲೇನ್ಸ್ ಮೆಮೋ ಅಂತ ಇರೋದ್ರಿಂದ ವರ್ಡ್ ಇರೋದ್ರಿಂದ ನೀವು ಮೆಮೋ ಹಾಕಿಲ್ಲ ಅಂತಾರೆ. 2 ಸೆಂಟೆನ್ಸ್ ಒಂದು ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಇಷ್ಟು ಹೊತ್ತು ಇದು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಬೇಕು, ಬರಬೇಕು, ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು, ಅರ್ಥ ಆಗಲ್ಲ. 5 ಪೈಸೆ ಬದುಕಿಗೆ 500 ರೂಪಾಯಿ ಖರ್ಚು ಮಾಡ್ತೀರಿ ಕ್ಲೈಂಟ್ ಇಂದ. 2 ಸೆಂಟೆನ್ಸ್ ಮೆಮೋ, ಓನ್ಲಿ 2 ಸೆಂಟೆನ್ಸ್. ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ, ಇಲ್ಲದ ಹೊರ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ. At the request of the learned counsel for the appellant, matter is passed over.
Number 42, Bhaktavachala.
But for the appellant, neither present physically nor through video conference. Results are forthcoming for his non-appearance. And for non-compliance of his objection. On 24/5/2023, this court has made the following observation. In spite of the above observation, the appellant has neither compared the direction dated 19/4/2021, nor compared the office objection, neither compared the directions dated so, nor compared the office objection, nor even showed any reasons for non-compliance. It is of the year 2019 and subsequent opportunities. Several and sufficient opportunities have already been granted. Hence, I do not find any reasons for granting further time. As such, the appeal stands to dismiss it for non-compliance of office objection as well as for non-compliance.
5th time non-compliance, Silver 43, Chikapajigowda.
For the appellant not present, neither through display nor video conference, no reasons for forthcoming ಅದೆಲ್ಲದು ಹಾಕಿ. On 24/5/2023, this court made the following observation. Of the above, the appellant has not complied with the office objection. In his appeal of the year 2019, several sufficient opportunities of not less than 5 times have already been granted. As such, I do not find any reason to grant further time. Hence, the appeal stands dismissed for non-prosecution, non-compliance.
Silver 44, Ananda K.
Order extracted 24/5. Yes.
Serial number 45, SR Kamalacharan.
Minor of this objection will comply with the code of litigation.
₹1,000 per day. How many days you want?
Yes, sir. Yes.
And counsel for the appellant who is physically present once again praise for observation made on 24/5/2023 was brought to his notice. Even according to him, the office objections are too trivial in nature, like mentioning the original suit number, which order alone, mentioning the correct OS number in the appeal memo, which is under challenge, removing the pencil marks, etc. Even to attend these office objections, the appellant has kept pending this appeal from the year 2009. As though the appeal could have been dismissed for non-compliance of office objection. However, considering the reason shown by him, at the final ultimate chance, today's accommodation as paid is granted, but imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court in a day from today, and filing a compliance memo along with original receipt to that effect in the registry within the said time. In case if the cost is not paid and office objections are not complied in total within the said time, the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. The office objections are not complied in their entirety. Registry to list this matter. 176. Yes.
Serial number 46, Siddharth Kuchandi.
₹1,000 cost per day, maximum 7 days time. How many days you want? ₹4,000 ಆಗ್ತದೆ 4 ದಿವಸ. ಹೇಳಿ ಬೇರೆ ಹೇಳಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ಮಾಡೋದಿದೆ ಬಾಕಿ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ ಅನ್ನೋದೇ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಏನೋ ಟೈಮ್ ಕೇಳಬೇಕು, ಕೇಳ್ತೀನಿ. The counsel for the appellant who is physically present once again prays for time. Next time, read the observation made on 24/5/2020. Next time, as per the above observation, the appeal Would have been dismissed for non-compliance of office objection. However, considering the reason shown by the appellant, who prays for 4 days accommodation, I am of the view that granting of any further time would be on imposing cost. Accordingly, imposing a cost of rupees payable by the appellant to the legal services committee of this court within a day from prudent filing, etc., etc. 4 days time, ultimately granted, not complained. Remove or yes, 4 days as a last chance with cost. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಅನ್ನೋದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ನಾನು ಕಾಸ್ಟ್ ಬಹಳ ಮಿನಿಮಮ್ ಆಗ್ತಿದ್ದೆ. ಬಿ ಎ ಮುಚ್ಚಂಡಿ ಏನಾಗ್ಬೇಕು ನಿಮಗೆ ರಿಟೈರ್ಡ್ ಜಡ್ಜ್? ಜಡ್ಜ್ ಮಗ ಡಿಲೇ 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 ಅಲ್ಲೊಬ್ಬ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಮಗ ಆಗಿ 4 ವರ್ಷದಿಂದ ನೀವು ಏನೂ ಮಾಡಲಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿಲ್ಲ. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಬಿ ನೋಟರೈಸ್ ಅಷ್ಟೇ. ತಗೊಂಡು ಹೋದ್ರೆ ಅಲ್ಲೇ ನೋಟ್ರಿ ಇರ್ತಾರೆ, 50 ರೂಪಾಯಿ ಕೊಟ್ರೆ ಸೀಲ್ ಹೊಡೆದು ಕೊಡ್ತಾರೆ, ತಗೊಂಡೋಗಿ ಹಾಕಿದ್ರೆ ಆಯ್ತು. 3 ನಿಮಿಷದ ಕೆಲಸ. 4 ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಿ. ಹೋಗಿ ನಿಮ್ಮ ತಂದೆಯವರಿಗೆ ಹೇಳಿ, ಐ ಹ್ಯಾವ್ ವರ್ಕ್ಡ್ ವಿತ್ ಹಿಮ್.
Number 47, Aditya MB.
Appellant you are praise for a weak side, finally you are not. But inverse work, praise for a weak side.
1,000 ರೂಪಾಯಿ ಪರ್ ಡೇ ಎಲ್ಲ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಬಂದಿದ್ರಿ, ಹೇಳಿದ್ದೀರಿ, ಇದನ್ನೇ ಎಲ್ಲ ಹೇಳಿದ್ದೀರಿ, ಎಲ್ಲದೂ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ, ಹಾಕೊಳ್ರಿ. ಎಷ್ಟಂತ ಬೇಡ್ಕೊಳ್ತೀರಿ? ಕೇಳೋರಿಗಾದ್ರೂ ಸ್ವಲ್ಪ ಸಂಕೋಚ ಆಗ್ಬೇಕು. ನನಗೆ ಕೇಳಿಸ್ಕೊಂಡೆ ಸಂಕೋಚ ಆಗ್ತದೆ. ನೋಡಿ, ಎಲ್ಲದೂ ಹೇಳಿ, ಲಾಸ್ಟ್ ಟೈಮು ಇದೇ ರೀಸನ್ ಹೇಳಿ ಎಲ್ಲದೂ ಮಾಡಿ ಅಲ್ಟಿಮೇಟ್ ಚಾನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೇನೆ. ಏನ್ ತಲೆ ಹೋಗಂತ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. Dates and events to be arranged chronologically. Detailed memo for valuation to be stated. Seal of BDA to be affixed. ಮುಗಿದೋಯ್ತು ಕತೆ. 4 ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಿ, ಇನ್ನೂ ಬೇಕು. ತಗೊಳ್ಳಿ. Learned counsel for the appellant who is physically present. ನೀನೆ 4 ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಆಬ್ಸೆಂಟ್ ಉಳಿದ್ರಿ. 5 ಮ್ಯಾಟರ್ ನಲ್ಲಿ. Physically present, praise for time. Once again, praise for time. On 4/5/2023, this court had made the following observation. In the light of the above observation, I do not find any convincing reason for granting further time. Accordingly, the appeal stands dismissed for non-compliance of office objection. Yes.
Bill number 48, method as a.
I may be permitted to retire a notice to.
Counsel for the appellant who is physically present. That he may be permitted to retire from appearing for the appellant after issuing retirement notice to him. Next line, on 24/5/2023, the court had made the following observation. In the light of the above observation and considering the fact that the appeal is pending since the year 2019, only for compliance of office objection, which includes filing of an affidavit with reasons by not by the party, but by the learned counsel appearing for the appellant, which also has not been done. But I am of the view that only to enable him to retire from appearing for the appellant, the court need not have to grant any time. As such, the appeal stands dismissed for non-compliance of office objection. Yes.
Number 49, NK Ramesh.
Papers are not interested to the case. But as short term, written, they have not given, even the message they have not sent. Officer objection have not been complied with.
The counsel for the appellant who is physically present submits that in spite of his best effort, the appellant is not cooperating with him to comply with his objection. With the right of the above, the perusal of the order sheet also would go to show that in this appeal of the year 2019, several and sufficient opportunities of not less than 5 times, even as ultimate opportunity was also granted to him. In the light of the above, when the 11th counsel for the appellant himself pleads his helplessness due to alleged non-cooperation by the appellant, it has to be inferred that the appellant is not interested in prosecuting the appeal and also to complain of the subjection. As such, the appeal stands dismissed for non-prosecution as well as for non-compliance of office subjection. Yes.
Still number 50, Ananda DB.
ಇವೆಲ್ಲೊಂದು dismissal format ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಕೌನ್ಸಿಲ್ absent ಇರೋದು. ಅದನ್ನ ಇಟ್ಟುಕೊಳ್ಳಿ. ಆರ್ಡರ್ ಶೀಟ್ 24/5/2023 ಸಿಗ್ನೇಟಿಂಗ್ ಕೊಟ್ಟಿದ್ದೇನೆ. Dismiss.
Still number 51,
Non-compliance, non-prosecution.
51, Saraswati C.
Not complete in spite of getting sufficient, not less than 5 times. That will be the case. Same order, exactly. Yes.
Still number 52, Joe Sebastian.
ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಲ್ಲಿ ದೇಶದ ಹಂಗೆ
The other option, one is dismissal for non-compliance. Another one is imposing cost at the rate of ₹1,000 per day. You said that you have completed all of his subjection. Some of the office subjection which were raised at the first instance till date not being complied. Now complied ಅಂತ ಎಲ್ಲದನ್ನು ಹೇಳಿದ್ರಲ್ಲ ನೀವು. ಕಾಸ್ಟ್ ಹಾಕಿದ್ ನನಗೇನು ಖುಷಿ ವಿಷಯ ಅಲ್ಲ ವಕೀಲ್ರಿ, ಸಂತೋಷದ ವಿಷಯ ಅಲ್ಲ. ಇದೊಂದು ನ್ಯಾಯಾಲಯ ಆಗಿ ಸ್ವಲ್ಪ ಸಾಮಾಜಿಕ ಜವಾಬ್ದಾರಿಯೂ ಇರ್ತದೆ. ಸಾರ್ವಜನಿಕರ ಹಣದಿಂದ ನಡೀತಕ್ಕಂತಹ ಒಂದು ನ್ಯಾಯದಾನ ವಿತರಣಾ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ನಾಗರಿಕರ ಪ್ರಜೆಗಳ ಒಂದೊಂದು ಪೈಸೆಗೂ ನಾವು ಗೌರವ ಕೊಡಬೇಕಾಗ್ತದೆ. ಕೇವಲ ಅಡ್ಜರ್ಮೆಂಟ್ ಕಾಂಪ್ಲೇಂಟ್ಸ್ ಫುಲ್ ಸ್ಟಾಪ್ ಚುಕ್ಕೆ ಕಾಮ ಸ್ಟಿಚ್ ಸರಿ ಮಾಡ್ರಿ OS ನಂಬರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೀರಿ ಅನ್ನೋದಕ್ಕೂ ಹಲವಾರು ವರ್ಷಾನುಗಟ್ಟಲೆ ನಾವು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಹೋದ್ರೆ ನಿಮ್ಮಗಳ ದೃಷ್ಟಿಯಲ್ಲಿ ಬಹಳ ಒಳ್ಳೆಯವನಾಗ್ತೇನೆ, ಮೇಲೊಬ್ಬ ಇರ್ತಾನೆ, ಅವನ ದೃಷ್ಟಿಯಲ್ಲಿ ನನ್ನಷ್ಟು ಸಮಾಜದ ಹಣನ ದುರ್ವಿನಿಯೋಗ ಮಾಡಿದವರು ಇನ್ನೊಬ್ರು ಉಳಿಯಲ್ಲ. ಸಾಮಾನ್ಯ ಮನುಷ್ಯ ಮಾಡೋದಕ್ಕೂ ನ್ಯಾಯಾಧೀಶ ತಪ್ಪನ್ನು ಮಾಡೋದಕ್ಕೂ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ. ಅವರು ಮಾಡಿದ್ರೆ ಕ್ಷಮೆ ಇದೆ, ನಾನ್ ಮಾಡಿದ್ರೆ ಕ್ಷಮೆ ಇಲ್ಲ. ಹಾಗಾಗಿಯೇ ನಾನು ಸಾಕಷ್ಟು ಅಂಶಗಳನ್ನ ಪರಿಗಣಿಸಿ 2019ನೇ ಇಸ್ವಿಯ ಅಪೀಲ್ಗಳು ಹಲವಾರು ವರ್ಷಗಳಾದರೂ ಏನೂ ಇಲ್ಲ, ಸಿಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಗಮನವೇ ಕೊಡಲ್ಲ. ಪ್ರೇ ಫಾರ್ ಟೈಮ್. ಕಕ್ಷಿದಾರಿಗೆ ಏನ್ ನ್ಯಾಯ ಕೊಡ್ತೇವೆ ನಾವು? ಹಾಗಾಗಿಯೇ ನಾನು ಕಾಸ್ಟ್ ಅನ್ನು ಹಾಕಲಿಕ್ಕೆ ಅನಿವಾರ್ಯತೆ ಗಮನಿಸಿದ್ದೇನೆ, ಹಾಕ್ತಾ ಇದ್ದೆ. ಹಾಕಿದ್ರು ಮಾಡ್ತಾ ಇದ್ದೆ. ಎಲ್ಲವೂ ಆದೇಶ ಪುಟದಲ್ಲಿ ಇರ್ತದೆ. By the click of the button, anybody can open the order sheets and read what has happened. Old days are gone. Now litigants sitting at their home can assess both the judge as well as the counsel. How the matter was conducted, how it went on, how a court proceeding goes, everything. ಕೇವಲ ನಾವು ಕಂಟೆಂಪ್ಟ್ ಅಂತ ಅಷ್ಟೇ ಇಟ್ಕೊಂಡಿರೋದ್ರಿಂದಾಗಿ ಜನ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಹೆದರ್ತಾರೆ. ತೆಗಿರಿ ಒಂದ್ಸರ್ತಿ ಕಂಟೆಂಪ್ಟ್ ಲಾ. ಜನ ಏನಾರು ಅತಿ ಹೆಚ್ಚು ಬೈಯದಿದ್ರೆ ಅದನ್ನ ಜುಡಿಷಿಯರಿಗೆ ಬೈತಾರೆ, ಬೇರೆ ಯಾರಿಗೂ ಅಲ್ಲ. ಯಾಕಂದ್ರೆ ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಆಗಿದೆ. ಆ ಜವಾಬ್ದಾರಿ ನಿಭಾಯಿಸುವಲ್ಲಿ ನೀವು ಸಹ ಪಾಲುದಾರರು. ಇಷ್ಟೆಲ್ಲ ಇದ್ದು ಏನೂ ಇಲ್ಲ. ನಾನು ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಮಾಡುವ ಕಾಲಕ್ಕೊಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ಅಂತ ಹೆಸಿಟೇಷನ್ ಇರ್ತಿತ್ತು ವಕೀಲರಿಗೆ. ಪೂರ್ವಾಶ್ರಮದಲ್ಲಿ ನಾನೇ ನಮ್ಮ ವಕೀಲರ ಜೊತೆಗೆ ಹೋಗ್ತಾ ಇದ್ದೆ. ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಹುಡುಗ ಇದ್ದಾಗಲೂ ಕೋರ್ಟಿಗೆ ಒಂದು ಸಣ್ಣ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ಮೈಯೆಲ್ಲ ಹಿಡಿಗಾತ್ರ ಮಾಡ್ಕೊಂಡು ಕೇಳ್ತಾ ಇದ್ರು. ಲಾಯರ್ ಗುರುರಾಜರಾವು, ಲಾಯರ್ ನಾರಾಯಣ ಸ್ವಾಮಿ, ಅದಂತವ್ರು ಮೊಫಿಜಲ್ ಏರಿಯಾದಲ್ಲಿ, ಎಲ್ಲಿ ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ನಲ್ಲಿಯೂ ಕೂಡ ನಾವು ಕಾಲ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ ತೋರಿಸ್ಬೇಕು. ಫಸ್ಟ್ ಟೈಮ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್, ಸೆಕೆಂಡ್ ಟೈಮ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್, ಥರ್ಡ್ ಟೈಮ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್, ಫೋರ್ತ್ ಟೈಮ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್, ಫಿಫ್ತ್ ಟೈಮ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್. ಯಾರೇ ಕಕ್ಷಿದಾರ ಕಾಸ್ ಲಿಸ್ಟ್ ಒಂದು ಕಾಪಿ ಫ್ರೀ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಳ್ಬಹುದು ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ. ನೋಡಿದ್ರೆ ತೋರಿಸ್ತಾನೆ, ನೋಡ್ರಪ್ಪ ನಿಮ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ 110 ಕೇಸ್ಗಳಿತ್ತು ಅಂದ್ರೆ 65 ಕೇಸ್ಗಳು ಬರೀ ನಾನ್ ಕಾಂಪ್ಲೈನ್ಸಿಗೆ. ಫಸ್ಟ್ ಟೈಮ್, ಸೆಕೆಂಡ್ ಟೈಮ್, ಥರ್ಡ್ ಟೈಮ್, ಫೋರ್ತ್ ಟೈಮ್, ಫಿಫ್ತ್ ಟೈಮ್. ಇರ್ಲಿ, ಅವರ ಪಾತ್ರ ಏನೇ ಇರಲಿ, ಪರಿಸ್ಥಿತಿ ಹೇಗೆ ಬಂದಿದೆ ನೋಡಿ. ನಮ್ಮ ವಿಚಾರಣಾ ಪಟ್ಟಿಯಲ್ಲಿ ನಾವು ಅಂಥವನ್ನೆಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು. 1ನೇ ಸರ್ತಿ, 2ನೇ ಸರ್ತಿ, 3ನೇ ಸರ್ತಿ, 4ನೇ ಸರ್ತಿ ವೆಚ್ಚ ಹಾಕ್ಬೇಕು. ಅಫಿಡವಿಟ್ ಹಾಕ್ರಿ, ಶೋಯಿಂಗ್ ದ ರೀಸನ್ ಫಾರ್ ನಾನ್ ಕಾಂಪ್ಲೈನ್ಸ್ ಅಂತ ಅಡ್ವೊಕೇಟ್ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡಬೇಕು. ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಹಳಷ್ಟು ಮ್ಯಾಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಫಿಡವಿಟ್ ಹಾಕ್ತಿಲ್ಲ. ಯಾಕೆ? ದ ಅಫಿಡವಿಟ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಬೈ ದಿ ಕೌನ್ಸಿಲ್, ನಾಟ್ ಬೈ ದಿ ಪಾರ್ಟಿ. ಆದ್ರೂ ಟೈಮ್. ಇದು ಹೇಳೋದು ನನಗೇನು ಸಂತೋಷ ಕೊಡಲ್ಲ, ಅತ್ಯಂತ ವೇದನೆ ವ್ಯಥೆಯಿಂದ ನಾನು ಹೇಳ್ತೇನೆ. ಪ್ರತಿ ದಿವಸ ಹೇಳ್ತಿದ್ದೇನೆ ಇದೆಲ್ಲದನ್ನು. ಎಲ್ಲವೂ ಕೂಡ ಅತೀವ ವೇದನೆ. ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಬಗೆಗಿನ ಅತೀವ ಗೌರವ. ಅದರಿಂದ ಎಂತ ಹಿರಿಮೆ ಗರಿಮೆಗೆ ಪಾತ್ರವಾಗಿದ್ದ, ಪಾತ್ರವಾಗಬಹುದಾದ, ಪಾತ್ರವಾಗಲೇಬೇಕಾದ ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲೂ ಕೂಡ ಹೀಗಾಗ್ತದಲ್ಲ, ಅದು ನನಗೆ ಪಿಚ್ ಅನ್ಸುತ್ತೆ. ಬಿಕಾಸ್ ಐ ಕಮ್ ಫ್ರಮ್ ದ ಸೇಮ್ ಅಸೋಸಿಯೇಷನ್. I don't find any reason to grant any further.
Please.
ಇಷ್ಟು ಎಲ್ಲಾ ಹೇಳಿದ ನಂತರವೂ ನಿಮಗೆ ಮತ್ತು ಸಮಯ ಕೇಳಲಿಕ್ಕೆ ಬಾಯಿದೆಯೇ? Executant name to be stated in block letters below their signature at wakalat and ranking to be stated. 10,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕ್ತೇನೆ. ನೀವು ಇದನ್ನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಆದ್ರೆ 10,000 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕಾಗ್ತದೆ. ನೀವು ಆಲ್ರೆಡಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೇನೆ ಅಂತಿದ್ದೀರಿ. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ 10,000 ರೂಪಾಯಿ ಕಟ್ಟೋದು ಬೇಡ. ನೀವು ಕಟ್ಟಬೇಕಾದ್ದಿಲ್ಲ. If you have complained, you need not pay. But registry has stated that as on date, it is still due. In aggrieved CARA, OS number and disposal date and court details to be stated correctly. ಯಾವ ಕೋರ್ಟಿನ ತೀರ್ಪಿನ ವಿರುದ್ಧ ನೀವು ಬಂದಿದ್ದೀರಿ ಆ ಅಸಲು ದಾವೆಯ ಸಂಖ್ಯೆ ಕೋರ್ಟಿನ ಹೆಸರನ್ನ ಸರಿ ಬರೀರಿ. ಇಂಥ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಅವಕಾಶ ಮಾಡಿ ಕೊಡ್ಬೇಕೆ? ವಕೀಲರಾದವರಿಗೆ ಅಪೀಲ್ ಹಾಕಿದವರಿಗೆ ಯಾವ OS ನಂಬರ್ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ, ಯಾವ ಕೋರ್ಟಿಂದ ಅಂತಾನೂ ಗೊತ್ತಿಲ್ಲ, ಏನೋ ಬರ್ದಿದ್ದಾರೆ ಅಂತಕ್ಕಂತಹ ನೆಗೆಪಾಟಲಿಗೆ ಈಡಾಗ್ಬೇಕೆ? ಬರವಣಿಗೆಯಲ್ಲಿ ಅಂತ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತಗೊಂಡು ವರ್ಷಾನುಗಟ್ಟಲೆ ಅದನ್ನ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು ನನ್ನ ದುಸ್ಥಿತಿ ನೋಡಿ, ಇಂಥದನ್ನೆಲ್ಲ ನಾನು ನೋಡ್ಬೇಕು, ಮರುಗಬೇಕು. ಇಷ್ಟೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ರು, ಹಲವಾರು ವರ್ಷದಿಂದ ಹೇಳ್ತಿದ್ದೇನೆ. ಯಾವುದೇ ಸಂಕೋಚವಿಲ್ಲದೆ ನಿರ್ಬೇಡೆಯಿಂದ ಮತ್ತಷ್ಟು ಟೈಮ್. ಇವೆರಡು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಡೇ 1 ಅಲ್ಲೇ ರೈಸ್ ಆಗಿದೆ. ನಂತರದಲ್ಲಿ ಐಎ ಹಾಕಿದ್ದೀರಿ, ಐಎಗಳಲ್ಲಿಯೂ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಯಾವುದೇ ಆಗ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ವೇನ್ರಿ? ಡೇಟ್ ಮಾತ್ರ ರಾಂಗ್ಲಿ ಮೆನ್ಷನ್ ಅಂದ್ರೆ ಅದಕ್ಕೇನು ಎಕ್ಸ್ಕ್ಯೂಸ್ ಏನ್ರಿ? ಇನ್ನಷ್ಟು ನಗೆ ಪಾಟಲಿಗೆ ಈಡಾಗ್ತೀರಿ. ವಕೀಲರೊಬ್ಬರಿಗೆ ಒಂದು ಡೇಟ್ ಕರೆಕ್ಟ್ ನೋಡಿ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಐಎನಲ್ಲಿ ಅಂತ ಕಕ್ಷಿದಾರ ಅನ್ಕೊಂಡ್ರೆ ಏನಕ್ಕೆ ಕಳ್ತಾರ ಅವರು? ಹೇಳಿ. ಇಷ್ಟೆಲ್ಲ ಇರ್ಬೇಕಾದ್ರೆ ನಾನು ಕಾಸ್ಟ್ ಅಂತ ಹೇಳೋದು ಏನಾದ್ರೂ ತಪ್ಪಿದೆಯೇ? ಬಿಲ್ಕುಲ್ ಇಲ್ಲ. The counsel for the appellant who is physically present once again prays for time to comply the remaining of his objection and also the office objection raised by the registry and IA 1/23. The perusal of the order sheet would go to show that several insufficient opportunities even as final last opportunity were all given to him of not less than 5 times. The appeal is of the year 2019. On the date 23/5/2023, this court made the following observation. Despite such an observation, the appellant has retained complaints of office objections still to attend with, which office objections are too trivial and simple in nature, like correctly mentioning the OS number and disposal date and court detail in the memorandum of appeal, showing the executant name in black letters below their signatures at Wakalatnama and mentioning the ranking. These office objections, which hardly requires 4 to 5 minutes to comply with, the appellant appears to have not evinced the interest from the date of filing of the appeal, which is of the year 2019. As such, as per the observation made on 23/5/2023, though the appeal could have been dismissed for non-compliance of office objection, however, in the best interest of justice, 4 more days time is granted, but imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within a day from today and filing a complaints memo, etc. In case if the cost is not paid and office objections are not complied in their entirety within the 4 days, registry to list this matter on 13/6, on which day the court may proceed to dismiss the appeal for non-compliance of office objection.
53 SR Deshpande.
It's formatted ready. Indela bandela same 24/5 extract. 5 times. So non-prosecution, non-compliance.
54, Virpaksha PH.
But
Not I mistake, not I was my directed my clerk to deposit 300. You are not supposed to impose 500 rupees.
ಹೌದ್ರಿ, ಎಲ್ಲದೂ ನೆನಪಿದೆ.
A bargain,
ಒಂದು ದಿವಸ ಒಂದು ತಮಾಷೆಯೂ ಮಾಡಿದೆ, ಅದು ನೆನಪಿದೆ.
bargain for 300.
ಹೌದು,
Under the impression of 300 is imposed, I got into deposit only.
ಅವತ್ತಿನ ದಿವಸ ತಮಾಷೆನೂ ಮಾಡಿದೆ ಅಲ್ವೇ? ದಾವಣಗೆರೆ ಮಂದಿ ಎಲ್ಲದರಲ್ಲೂ ಚೌಕಾಸ ಮಾಡ್ತಾರೆ, ಚೌಕಾಸ ಮಾಡಬೇಡ್ರಿ, 500 ರೂಪಾಯಿ ಕಟ್ಟಿ ಅಂತಾನೂ ಹೇಳಿದೆ ನಾನು. ಅಷ್ಟಾಗಿಯೂ ನೀವು ಕಟ್ಟಲಿಲ್ಲ, ಕಡಿಮೆ ಕಟ್ಟಿದ್ದೀರಿ. ಇಂಟೆನ್ಷನ್ ಅಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತಿಲ್ಲ ವಕೀಲ್ರೆ. ಇಂಟೆನ್ಷನ್ ಯಾಕೆ ಅಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಲಿ ನಾನು? ಇಂಟೆನ್ಷನ್ ಅಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತಿಲ್ಲ. ಕಾಂಪ್ಲೇನ್ಸ್ ಆಗ್ಲಿಲ್ಲ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗೋಲ್ಲ.
Sometimes what we lack is there. For that I have informed them. They have told me to come on today. And Lord, case Lord, I will pay 200 rupees today. Not in case your lordship is not intended to grant any, let it be, this for now. Pay 200 rupees.
Counsel for the appellant is physically present and submits that due to inadvertence cost imposed on 23/5/2023 was paid in short by a sum of ₹200 and that you may good the deficit in the cost. The registry right now. However, with respect to the non-compliance of office subjection, which have not yet been attended to by him, in spite of imposing the cost and passing and making a detailed observation on 23/5/2023, the learned counsel expresses his helplessness of non-cooperation by the appellant. To pay the deficit court fee, which was
Other objections, what I can try today itself. Only major objection is.
ಅದರ್ ಅಬ್ಜೆಕ್ಷನ್ ನೀವು ಮಾಡ್ಲಿಲ್ಲ, ಹೇಳಿದ್ರು ಮಾಡ್ಲಿಲ್ಲ, ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಮಾಡ್ಲಿಲ್ಲ.
ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ನನಗೆ ಕಷ್ಟ ಇಲ್ಲ.
ಕಷ್ಟದ ಪ್ರಶ್ನೆ ಅಲ್ಲ ವಕೀಲರೇ, ನೀವು
ಒಟ್ಟಿಗೆ
ಈಗ ಮಾಡ್ತೀನಿ ಅನ್ನೋದು ಮೊನ್ನೆಗೂ ಮಾಡ್ಬೋದಿತ್ತು, ಮುಂಚೆನೂ ಮಾಡ್ಬೋದಿತ್ತು.
ಕೋರ್ಟ್ ಫೀ ಅಡ್ಮಿಟ್ ಮಾಡೋಣ ಅಂತ.
ಏನ್ ತಗೊಂಡ್ರಿ?
This is for
ಈಗ ಎರಡು ಆಪ್ಷನ್ ಇದೆ. ಒಂದು ಅಡಿಷನಲ್ ಕಾಸ್ಟ್ ಹಾಕಿ ಒಂದು ವಾರ ಸಮಯ ಕೊಡಬಲ್ಲೆ, ಪೆರಿಮಿಟರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ. ಇಲ್ಲವೇ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಕಾಂಪ್ಲೈನ್ಸ್ ಅಂತ ಮಾಡಬಲ್ಲೆ. ಅಲ್ಲಿ ನಿಮಗೆ ಯಾವ್ದು ಬೇಕೋ ಅದನ್ನು ಮಾಡಬಲ್ಲೆ ನಾನು. ಎರಡೂ ಆಪ್ಷನ್ ಇದೆ.
It all depends upon the amount of cost.
ಅಲ್ಲ ಹೌದು, ನಿಮ್ಗೆ ಅಕ್ಷರಾರಿಗೆ ಹೇಳ್ಬೇಕಯ್ಯ, ನೀನ್ ಬಂದು ನೋಡು, ನೀನ್ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟದೇ ಇದ್ದಿದ್ರಿಂದ ನೀನ್ ಒಂದ್ 1,000 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕಾಗಿದೆಯಪ್ಪ.
ಅಷ್ಟಿನ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವ್ರು.
ಹಾಗಾದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋರು ಆಮೇಲೆ ರಿಸ್ಟೋರ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಏನ್ ಗ್ಯಾರಂಟಿ ಇದೆ ಕಾಸ್ಟ್ ಹಾಕಿ ಟೈಮ್ ಕೊಟ್ಟು ಬಂದು ಕೊಡ್ತಾನೆ ಅಂತ?
ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅದೇ ಹಾಗಾಗಿ
ಫೋನ್ ಮಾಡಿ
ಇರ್ಬೋದು, ಕೆಲವೊಮ್ಮೆ ಆಗ್ತದೆ. ಹಲವಾರು ಸನ್ನಿವೇಶದಲ್ಲಿ ಕಕ್ಷಿದಾರಗಳೆಲ್ಲ ಬರ್ತವೆ ಅಂತಾರೆ, ಬರಲ್ಲ, ಕೋಆಪರೇಟ್ ಮಾಡಲ್ಲ. ಎನ್ ಕೆ ರಮೇಶ್ ಅವ್ರ ಮ್ಯಾಟರ್ ನಲ್ಲೂ ನೋಡಿದ್ರಿ, ಅವ್ರು ಹೇಳಿದ್ರು. So I am prepared and willing to comply the office objection. Client is not cooperating, hence lordship will proceed to dismiss ಅಂತ ಮಾಡಿ. ಎಷ್ಟಂತ ನೀವು ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ? ಅವರಿಗೆಲ್ಲ ಹೇಳಬಲ್ರಿ, ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಲ್ರಿ, ತಿಳಿಸ್ಬಲ್ರಿ, ಅಲ್ಲಪ್ಪ ಈಗ ಆಗ್ತದೆ ಅಂತ. ಅಷ್ಟಕ್ಕೂ ಮೀರಿ ಅವ್ರ ಆಸಕ್ತಿ ತೋರಿಸ್ತಾ ಹೋದ್ರೆ ವಾಟ್ ಕ್ಯಾನ್ ಕೌನ್ಸಿಲ್ ಡೂ? In the light of the above, when the appellant himself is said to be not evincing, appellant themselves are said to be not evincing interest in cooperating to comply the office objection. The same shows that the appellants are not interested in prosecuting the matter and also in complying the office objection. Hence, I do not find any reasons to grant further time. ಮುಂಚೆ ಇದನ್ನು ಮಾಡಿ on 23/5/2023, this court made the following observation and I gather will be still. Accordingly, the appeal stands to dismiss it for non-compliance of office.
Bill number 55, Prakasha M.
Land counsel for the appellant who is physically present has filed a memo seeking withdrawal of this appeal as not trust. In view of the memo and supporting submission, the appeal stands dismissed as not trust.
This is the non-compliance number 56. B, open now.
Commented for it, counsel for the appellant observation 456 opportunities. Business to non-prosecution, non-compliance.
Still number 57, 8 the non-compliance 7. Non-compliance, still number 57.
Subject for the appellant. For the objection notes with respect to the description of defendant number 3 and defendant number 6 before the trial court. Each 10 minutes, Lordship may
1 minute. Yes, please.
page number 10 minutes.
Yes.
Defendant number 2 is shown as K. Jairam. And again, defendant number 3 is shown as DK Jairam.
Yes.
This is wrong mentioning these two. And also not defendant number 6 shown as K. Ananda.
Yes.
But he is K. Anand Kumar.
Yes.
Notes now appeal is filed by the defendants. Not if the defendant notes the first time notes it was brought to our notice. Therefore, notes page number 3 notes in the description. Description we have mentioned not that he has been wrongly shown before the trial court. But this is the office action where we stand towards. The trial court we didn't represent the parties. We have instructed notes them to
So I will dismiss the appeal for the time being.
also notes in respect of only notes
the appellant number 6 and 3, but otherwise, Lordship may observe.
Or 500 rupees per day, cost maximum 10 days time. Which option you prefer?
Lordship may impose cost, I will instruct my clients, if they don't go ahead, then Lordship may record that.
The learned counsel for the appellant is physically present and once again pray for time to comply officer. Next line. In order to avoid repetition, observation made on 24/5/2023 is also to be read as a part of today's observation. Next line. The submission of the learned counsel for the appellant that the discrepancy in showing the name of the appellant number
2 and 6.
one bracketನಲ್ಲಿ BK Rajanna instead of BK Jaira. And appellant number 6, Shri K Anand Kumar, bracketನಲ್ಲಿ instead of K Ananda. Is not acceptable. If at all there is any mistake or discrepancy in the description of the parties, as shown in the input judgment, the appellant should have approached the concerned trial court and get the alleged error corrected. A mere mentioning as a note in below the name of the parties in the cost title would not cure the alleged discrepancy or the defect, if any. In fact, except reflecting the name and addresses of the parties with their respective ranking as depicted in the trial court records, the appellant is not expected to make any additions in the cost title of a memorandum of appeal. Next, in the instant case, the appellant should have approached the trial court and get the needful done and file the appeal. Instead of doing the same, he cannot tailor the nomenclature of the parties as the appellant feels like. As such,
I request
since
15.
the office objection sustains and sufficient opportunities of not less than 6 times have already been, not less than 8 times have already been granted to the appellant, the appeal. This has to be dismissed. However, take into consideration the submission made today as an ultimate opportunity. However, take into consideration the submission made today, the court asked the learned counsel for the appellant that granting of further time would be only and cost at the rate of ₹500 payable by the appellant to the Legal Services Committee of this court. For this, the learned counsel for the appellant has opted, has chosen how many days you want.
15 days, 5,000.
15 days, 7,500. 15 days time as spread is granted at a cost of ₹500 per day into 15 equals ₹7,500. Payable by the appellant to the Legal Services Committee of this court within a week from today and filing a complaints memo along with. Proceed to that effect in the registry within the said time. Non-compliance of office subsection within 15 days from today would lead this court to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if the office objection, in case if the cost is not paid and office objections are not complied within the time registry to list this matter on 19/6/2023.
Serial number 58, warrant copyright KJ Jagdisha.
Yes, please. Make use of the microphone, please.
Lord, I've paid the cost,
When did you pay the cost?
26th, my lords.
20?
26th, my lord. 26, by
Did you intimate the registry as directed about the payment of the cost?
no, my lords.
Why?
Lords, as intending to do, but then my office person wasn't position to do it at that point of time. So yeah, but just that mistake. my lord.
Apology won't do all these things. They are very sacred words. Probably it has lost its meaning by its continuous improper use by several of the learned counsels. Yes. Why did you not comply the office objection?
Because that, that extent, I've already made an application to the sub-registrar office. And another week's time.
It is between you and the sub-registrar, not between you and the registry, or not between you and the court.
Yes, my lord.
Yes.
So that extent, I will request a week's time, my lords. I've already applied for it.
1,000 rupees per day.
Slightly short
No.
date maybe.
Look here. Look here.
Yeah.
How much we have to write? Entire history, every detail, everything we have to write. ನೀವು ಸುಲಭದಲ್ಲಿ ಸಮಯ ಕೇಳಿ ಬಿಡ್ತೀರಿ 1 week time, 2 week time. ಒಂದು ಸರ್ತಿ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಂದ್ರೆ 15 ಜನ ಕೆಲಸ ಮಾಡಬೇಕು. ಅಷ್ಟು ಸೆಕ್ಷನ್ಗಳಿಗೆ ಅಷ್ಟು ಬ್ರಾಂಚ್ಗಳಿಗೆ ಎಲ್ಲ ಹೋಗ್ಬೇಕು, ಫೈಲ್ ಮೂವ್ಮೆಂಟ್ ಆಗ್ಬೇಕು, ಎಲ್ಲರೂ ನೋಟ್ ಹಾಕ್ಬೇಕು, ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು, ವೆರಿಫೈ ಮಾಡಬೇಕು, ಕ್ಲರ್ಕ್ ಮಾಡಿ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಮಾಡಿದ ಯಾರು, ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೇಳಿದ್ರೆ DR ಅಥವಾ JR, ಎಲ್ಲರೂ ಅದನ್ನು ಓದಿ ನೋಟು ಗೀಟು ಎಲ್ಲ ಹಾಕ್ಬೇಕು. ಆಮೇಲೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಲಿಸ್ಟಿಂಗು, ಟೈಪಿಂಗು, ಪ್ರಿಂಟಿಂಗು, ವೆಬ್ ಹೋಸ್ಟಿಂಗು, ಕಂಪ್ಯೂಟರ್ ಸೆಕ್ಷನ್. ಎಷ್ಟು ಜನ ಕೆಲಸ ಮಾಡ್ಬೇಕು ನೋಡಿ. ಅನ್ನೆಸೆಸರಿ. ಅವರೆಲ್ಲರಿಗೂ ಸಂಬಳ, ಲೈಟು ನೀರು ಖರ್ಚು, ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಖರ್ಚುಗಳು, ಸ್ಯಾಲರಿ, ನನ್ನ ಸಂಬಳ, ನಯಾ ಪೈಸೆ ಏನು ಪ್ರೋಗ್ರೆಸ್ ಇಲ್ಲದೆ ನನಗೆ ಸಂಬಳ. ದುಡ್ಡು ನಿಮ್ದಲ್ಲ ಸ್ವಾಮಿ, ಟ್ಯಾಕ್ಸ್ ಪೇಯರ್ಸ್ ಅಷ್ಟೇ. ನೀವು ಕೇಳಿ ಬಿಡ್ತೀರಿ, ಒಂದು ವಾರ ಟೈಮ್ ಎಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅದಕ್ಕೆ ಇಷ್ಟು ಉದ್ದ ಬರೆದು 2,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕಿ ಮಾಡಿದ್ದೇನೆ. ಅಷ್ಟಾಗಿಯೂ ಏನೂ ಇಲ್ಲ.
As soon as before the payment of the
ನೀವು ಮಾಡಿದ್ದು
already applied in the.
ನೀವು ಅವಾಗ್ಲೇ ಹೇಳ್ಬೇಕಿತ್ತು, ಸ್ವಾಮಿ ನಾನು 1 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ, ಕಾಸ್ಟ್ ಬೇಕಾದ್ರೆ 20,000 ಹಾಕಿ ಒನ್ಸ್ ಫಾರ್ ಆಲ್ 1 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ, ಪೂರ್ತಿ ಮಾಡಿ ಬಿಡ್ತೇನೆ. ನನ್ನ 30 ಮಂದಿಯ ಕೆಲಸ ಉಳಿತಿತ್ತು, 30 ಮಂದಿಯ ಕೆಲಸ ಉಳಿತಿತ್ತು, ಕೊಡ್ತಿದ್ದೆ. Yes, tell me.
On that day itself, I've already went and made the submission. So week's time, I will make sure I will get the document and I will comply with the office suggestion.
1,000 rupees per day cost. I grant you time.
Delivery.
The counsel for the appellant who is physically present submits that cash paid the cost of rupees 3,000 imposed on 22/5/2023 on 25/5/2023 itself. However, he concedes that he has neither filed the complaints memo nor the receipt in the registry, since there is a specific direction for him to file a complaints memo along with original receipt to that effect in the registry within the said time. As per the order dated 22/5/2023, the appellant to comply the same in the forenoon session without fail. Failing which the court may proceed to pass appropriate order which may be serious in its nature. Next line, the learned counsel in spite of alleged payment of the cost also has not complied with the office objection and still praying for 1 more week's time to comply office objection. The appeal is of the year 2018 and sufficient opportunities of all sorts like final, last chance, final, last, etc. were all given to him of not less than were all given to him for 9 times, despite which the appellant has not evinced interest in complying of his objection. As such, though the appeal deserves to be dismissed for non-prosecution, however, in the best interest of justice, imposing a cost of a sum of rupees 5,000 payable by the appellant the Legal Services Committee of this court within 3 days from today and filing a complaints memo along with original receipt to that effect in the registry within the said time. As an ultimate opportunity, 1 week time as prayed is granted, failing which the appeal stands dismissed on its own with effect from 8/6/2023 without any further order by this court. In such an event, if the appeal stands dismissed by virtue of this peremptory order, the Legal Services Committee would be at liberty to recover the cost of rupees 5,000 ordered by this order today by executing today's order as a decree, and the recovery can be made as an arrears of land revenue from the appellant. To enable the Legal Services Committee in that regard, the registry to transmit a copy of today's order to the Legal Services Committee of this court immediately.
Still number 59. Narayan Reddy M. Umesh.
In view of the fact that the appellant A1 to A3 have engaged the services of another counsel, Sri B.N. Umesh. The memo of retirement filed by the previous counsel, Sri M. Narayan Reddy, is taken on record, and Sri M. Narayan Reddy is permitted to retake from appearing for appellant number 1 to 3 in this matter. Just put a memo ಯಾವುದು? Memo won't do. What statement who are making, who are the LRs of which person, and whether they are on already on record or not should come through a sworn affidavit. The learned counsel for the appellant submits that since memo dated 17/2/2022 filed by him would not serve the purpose of treating appellant number 3 as the sole surviving legal heir of deceased respondent number 2. He would not pass the said memo and file a necessary application, for which he requires a week's time. Next line. A week's time as spread is granted.
Respondent
Dated 17/2/2023 accordingly stands to dispose of.
respondent number 2 ಅಂತ ಬಂತು, appellant number 2 ಅಂತ.
Appellant number.
Still number 60. N. Kumar.
None appear. Await service of emergent notice to respondent. Is the matter wrong? 96. Yes.
Hearing on integrated application number 61. We are Balraj. Number 61. We are Balraj.
For the appellant. Let represent physically not through video conference. There is the memorandum of appeal and the memorandum of appeal, impugn judgment and the pending IAs. And the view that before proceeding to pass any order on IA 2/2019, the notice be ordered upon respondent both on the main appeal and on pending IA issue. Pending IA. Accordingly, issue notice to the respondents both on the main appeal as well on pending IAs. Appellant to pay the necessary process and furnish copies in the registry if not already done in a week from today.
Bill number 62, Ashok Kumar, KR.
Yes, my
Connected.
lord. I appear for the appellant, my lord. Filed a memo for withdrawal with a liberty to file a full-fledged suit. Plaintiff's appeal, my lord.
The counsel for the appellant is appearing through video conference. I make the submission regarding not pressing the memorandum of not pressing the appeal. The appellant also has filed a memo dated 35/2022 in that regard. Any of the memo supporting submission.
Same submission.
Where is the necessity of reserving any liberty? Is it not say by statute you have that liberty, inherent liberty?
Very well, very well.
Yes. In view of the no supporting submission, the appeal stands. Disposed of as not pressed.
Any kind observation, my lord? Any such observation will enable.
No denial of the liberty.
No need. Please.
No denial of the liberty is made.
Please. Same submission in the next matter.
In view of the disposal of the main appeal, the pending IS does not survive for consideration. 62/1 same order idea.
Yes,
(62/1) same order.
Please.
Yes.
Mature.
Admission matter, seal number 63, B. Janardhan. Admission matters. Serial number 63, B. Janardhan.
For the appellant, neither represent physically nor through video conference. There is a memorandum of appeal and the impugn. Yes, ma'am. considering the reason. Okay. Admit to TCRO paper book 8 weeks.
Till
Yes.
64, Sri Hari Devi.
To one of the days accommodation.
Learned counsel from both sides present. The learned counsel for the appellant pays for a short accommodation, to which time is granted.
Till number 65, Director Gogi.
Appearing for appellant, your lordship. Lordship, there is some inconvenience today. I request for a short accommodation.
Counsel for the appellant appearing through video conference pays for a short accommodation means the matter could not be proceeded. Yes.
Till number 66, Rajeshwara PM.
Counsel for the appellant prays for time hence the matter could not be proceeded.
Till number 67, Shankar Reddy.
Since appellant it was but then court granted several things. The appeal, the appellant filed appeal only to for executive. The appellant has complained all other lifts are. Compared entire arrears and been for up to date.
One moment.
And execution, quite execution by that.
Yes. Because of the microphone, please.
Appellants yes person on health ground ಒಂದು ವರ್ಷ ಟೈಮ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಇವತ್ತಿನ ಅಪ್ಡೇಟ್ ನಾವು ಅರಿಯರ್ಸ್ ಮೀನ್ಸ್ ಪ್ರಾಫಿಟ್ ಏನ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಅದೆಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ. ಸೊ ಇಲ್ಲಿಂದ ಒಂದು ವರ್ಷ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಅವ್ರ ವೈಫ್ ಎಲ್ಲ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಈಗ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಅವರು ಬೇರೆ ಕಡೆ ಹೋಗಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡೋದಕ್ಕೆ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅಲ್ಲ ರೀ, ಈ ಸಂದರ್ಭದಲ್ಲಿ ಬೇರೆ ಕಡೆ ಮನೆ ಮಾಡ್ಲಿಕ್ಕೆ ತೊಂದರೆ ಆಗ್ತದೆ ಅಂದ್ರೆ ಇನ್ನೊಂದು ವರ್ಷ ಆದ್ರೆ ಇನ್ನು ಜಾಸ್ತಿ ವಯಸ್ಸಾಗಿರುತ್ತೆ ಅಲ್ವೇ ನಿಮಗೆ?
ನಾವು
ತೊಂದರೆಗಳು ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಲ್ವೇ?
ತಕ್ಷಣಕ್ಕೆ ಅವರು ತುಂಬಾ ತೊಂದರೆ ಇರೋದ್ರಿಂದ ಏನ್ ಅಡ್ಮಿಟೆಡ್ ರೆಂಟ್ ಇದೆಯಲ್ಲ ಅದನ್ನ ಕಟ್ಕೊಂಡು
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ಈಗ ರೆಂಟ್ ನೀವು? ಡಿಕ್ರಿ ಆದ್ರ ಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
ಫೈಲ್ಡ್ ಮೆಮೋ
ಡಿಕ್ರಿ ಆದ್ರ ಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ರೆಂಟು?
ಇವತ್ತಿನವರೆಗೂ 17,0605. $6 ಲಕ್ಷ ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡಬೇಕು ಅದು ಅಡ್ಜಸ್ಟ್ ಆಗಿದೆ.
ಆಗಸ್ಟ್ 12ನೇ ತಾರೀಕು 2022ನೇ ಇಸ್ವಿಯ ನಂತರ ನೀವು ಎಷ್ಟು ದುಡ್ಡನ್ನ ರೆಂಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಿ?
12 ಆಗಸ್ಟ್ 12, 2022 ಕೋರ್ಟ್ 16,10,000 ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಅರಿಯರ್ಸ್ ಅಂತ. ಅದರಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ 6 ಲಕ್ಷ ಎಸ್ ಆಯ್ತು, 10,10,000 ಅರಿಯರ್ಸ್ ಇತ್ತು. ನಂತರದಲ್ಲಿ ಆಸ್ ಪರ್ ನಿಮ್ಮ ಅದರಲ್ಲಿ ಯಾವ್ಯಾವ ತಾರೀಕಲ್ಲಿ
ನಾನು ನಿಮಗೆ ಕೇಳ್ತಾ ಇರೋದು ಒಂದೇ ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ. 12/8/2022 ನಂತರ ಇವತ್ತಿನವರೆಗೆ ನೀವು ಎಷ್ಟು ಹಣವನ್ನು ಕೊಟ್ಟಿದ್ದೀರಿ?
lakhs, 50,000 some change. 14 ಲಕ್ಷ 3,50,000 case of trial court pending hearing 3,50,000 on 6/9/22 ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್. ಇವಾಗ
6922 ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
3,50,000. On 25/10/22.
3,50,000 ಹಿಂದಿ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Yes, pending ಇರ್ಬೇಕಾದ್ರೆ 25/10/22.
23rd
25/10/22.
2510 22 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
140.
1,40,000.
On 7/3/23.
7/3
7/3/2023.
7th March
7th March.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
8,50,000. 8,50,000.
8,50,000.
26/5/23.
26/5/23
23. 2 lakhs. 2 lakhs. Again on 26/5/23 on same day, 1,60,605. Now this advance amount has been adjusted. 6 lakhs.
ಈ ಎಲ್ಲ ಅಮೌಂಟ್ ಗಳನ್ನು ನೀವು ಕೋರ್ಟಿನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ ಹೇಗೆ?
Online ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಅವ್ರ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್. ಅದನ್ನ ಯಾರು ಅವರು ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್.
ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಸೂಟ್ ಇವತ್ತಿನವರೆಗೆ ನೀವು ಈಗ ಹೇಳಿದ ಪೇಮೆಂಟ್ ಅನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆದೇನಾದ್ರೂ ಕೊಟ್ಟಿದ್ದೀರಾ? ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ದ ಸೂಟ್ ಟಿಲ್ ಡೇಟ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರೇ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲಿವರೆಗೂ ನಾವು ನಂತರದಲ್ಲಿ ಅಂತ ಆಸ್ ಪರ್ ಅದ್ರ ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆನ್ 12/8/2022 ಅಲ್ಲಿ ಅವತ್ತಿಗೆ 16,10,000 ಅರಿಯರ್ಸ್ ಇತ್ತಂತ ಅದ್ಮೇಲೆ 3,50,000 ನಾವು ಪಾರ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀವಿ. ಅರಿಯರ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಮ್ ಡಿಫೆನ್ಸ್ ಸ್ಟ್ರಕ್ ಅಪ್ ಆಯ್ತು.
Even if it is considered that say you have paid the amount as stated by you, amount into 17 lakh rupees, still you are due to the plaintiff a sum of rupees 6,80,000.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಆಸ್ ಆನ್ 12/8/22 ಅವತ್ತು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡೋ ಸಂದರ್ಭಕ್ಕೆ 16,10,000 ಅರಿಯರ್ಸ್ ಆಗಸ್ಟ್ 2022. ಅಲ್ಲಿಂದ ಸೆಪ್ಟೆಂಬರ್, ಅಕ್ಟೋಬರ್, ನವೆಂಬರ್, ಡಿಸೆಂಬರ್ 4 months ಪ್ಲಸ್ ಈಗ 6 months ಟೋಟಲ್ 10 months. 10 months ಗೆ 70,000 7 lakhs ಬರುತ್ತೆ ಸರ್. ಅಪ್ ಟು ಡೇಟ್ ಇವತ್ತಿನವರೆಗೂ ನಾವು ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀವಿ ಸರ್. ಅಡ್ವಾನ್ಸ್ ಏನು 6 ಲಕ್ಷ ಇತ್ತಲ್ಲ ಅದು ಇದ್ರಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಆಗಿದೆ.
ಅಡ್ಜಸ್ಟ್ ಈಗ ಅಲ್ಲ, ಅಡ್ಜಸ್ಟ್ ನೀವು ವೆಕೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಈಗ 6 ಲಕ್ಷ ರೂಪಾಯಿ ನೀವು ಕೊಡಬೇಕು, ಖಾಲಿ ಮಾಡ್ತಾ ಅದನ್ನು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ತಗೊಂಡ್ಬನ್ನಿ, ಆಮೇಲೆ ನೀವು ಅಮೌಂಟ್ ತಗೊಂಡ್ ಬನ್ನಿ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರ್ತೇನೆ, ಆಮೇಲೆ ನಿಮ್ಮ ಏನ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಇದರಲ್ಲಿ ಈಗ ಏನಾಗಿದೆ ಪ್ರೆಸೆಂಟ್ ಸಿಚುವೇಶನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ, ಡೆಲಿವರಿ ವಾರಂಟ್
ಅಲ್ಲಿಗೆ ಹೋಗಿ ಕಟ್ರಿ, ಅಲ್ಲಿಗೆ ಹೋಗಿ ಕಟ್ಟಿ ಅಮೌಂಟ್. ಅವಾಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನು ಉಳಿದಿರ್ತದೆ ಅವರಿಗೆ? ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವು ಅಪ್ ಟು ಡೇಟ್ ಎಲ್ಲದು ಕಟ್ಟಿದ್ದೀರಿ. ವಾಟ್ ದೇ ಕ್ಯಾನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಎಕ್ಸೆಪ್ಟ್ ದ ಡೆಲಿವರಿ ವಾರಂಟ್.
ಪೊಸಿಷನ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಚಾಲೆಂಜ್
ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ತಗೊಂಡು ಬನ್ನಿ.
ಯಾಕಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಡೆಲಿವರಿ ವಾರಂಟು ಆಗ್ತಿದೆ ಸ್ವಾಮಿ. ಈ ತಕ್ಷಣಕ್ಕೆ ಅವ್ರು ಸ್ಟೇ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಆಚೆ ಬಂದ್ಬಿಟ್ಟು ಮತ್ತೆ ಅಪೀಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
ಅವ್ರು ಆಚೆ ಬರೋದ್ ಬೇಡ, ದುಡ್ಡು ತಗೊಂಡು ಕೋರ್ಟ್ ಹಾಲ್ ಒಳಗೆ ಹೋಗ್ಲಿ, ಡೆಲಿವರಿ ವಾರಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಲ್ಲ. ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಅಲ್ಲಿ ಕೊಡ್ಲಿ. ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಕೊಡದಾಗ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಕೊಡುವ ನಿಮಗೆ,
ಯಾಕಂದ್ರೆ
ಮಾಡಿಫೈಡ್ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್.
ಇಮಿಡಿಯೇಟ್ ಆಗಿ, ಯಾಕಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಈಸ್ ಆನ್ 23/6 ಮೈಲಾಡ್. ಈಗಾಗಲೇ ಡೆಲಿವರಿ ವಾರಂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ನೀವು ಅದನ್ನೇ ಹೇಳಿದ್ದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ವಕೀಲ್ರೆ, ನೀವು ಮನೆಯಲ್ಲಿದ್ದೀರಿ, ಮನೆ ಮಾಲೀಕರಿಗೆ ಬಾಡಿಗೆ ಕೊಡ್ಬೇಕೋ ಬೇಡ? ಬಾಡಿಗೆ ಕೊಡಿ. ಬಾಡಿಗೆ ಕೊಡಿ. ನಿಮ್ಮನ್ನು ಎವಿಕ್ಷನ್ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಾಡದೇ ಇರೋ ಹಾಗೆ ಒಂದು ಶಾರ್ಟ್ ಡ್ಯೂರೇಷನ್ಗೆ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯತೆ ಇದ್ರೆ ಕೊಡು.
ಯಾಕಂದ್ರೆ ನಾನು ಅದನ್ನ ಅಮೌಂಟ್ ರೆಡಿ ಮಾಡಿಸಿ ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದೆ ಅದ್ರ ಪ್ರಕಾರ ನಾನು ಇರ್ತೇನೆ. ಯಾಕಂದ್ರೆ ಈಗ ಯಾಕಂದ್ರೆ ಇದನ್ನ ಮೂವ್ ಮಾಡಿದ್ದು ಅವ್ರ ಹತ್ರ ನಾವು ಮಾತಿಲ್ಲ, ಅದ್ರ ಸೈಡ್ ಹತ್ರ ನಾವು ಕೌನ್ಸಿಲ್ ಹತ್ರ ಮಾತಾಡಿದ್ದೀವಿ. ಅವ್ರ ಹತ್ರ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ. ಅವರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಸರಿ ಹೇಳ್ತಾ ಇಲ್ಲ, ನಿಮಗೆ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಅಲ್ವೇ? ಬಾಡಿಗೆ ಕೊಡಿ, ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಕೊಡೋಣ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. ಫಾರ್ ದ ಅಪೋನೆಂಟ್. Physically present. Heard his submission, even according to him, according to madam, though he submitted that a sum of rupees. Last amount you put is 1,60,605. Aden odd amount bantadu. Though he submitted that a sum of rupees 17,605 is paid to the present respondent, who is alleged to be the landlord of the property. However, even according to the direct counsel for the opponent, the total arrears of the rent till 3/6/2023 as per the impugned judgment, total arrears, but total amount of rent would be rupees 23,80,000. As such, the same is short by a sum of rupees 6 lakh. The legal counsel for the appellant prays for a day's accommodation. Is the matter on 2/6. Yes. That's great.
Synopsis file. Just file Monday. Formal session. So now, just to find this problem. Pass the matter. Serial number 3. Sushil Kumar Vikram.
What is your good name, please?
Myself, Surya. Surya.
Who doesn't hold wakala in the matter?
No, I signature with my senior. He was in the court 10:30 only it was called out.
The signature does not tally with the one in the wakala. Yes, immediately, right now. Tapamani. Yes, next.
Serial number 41. Serial number 41, HR Anantha Krishna.
Right.
But again, that will counsel for the other physically present and submits. It's a memo of complaints. Register to verify and proceed. Yes.
Final disposal matter, serial number 68. Dinesh Rao, RPM. Ellen Rowan.
The due for payment of the mean profit at rupees 1,000 per month, right? It's-
But initially they have filed an case RRC for stating I'm a tenant, I have to vacate. This honorable court has dismissed their case stating that there is no such jurial relation with the liberty to file for a fresh suit for declaration. They have again they have filed the ejectment suit and they have claimed for a declaration on their title deed, my lord. Past 1980, I am in possession. I am claiming my adverse position on the property, my lord. There is a transaction. This honorable court has already rejected that there is no landlord and tenant relationship between the appellant and the respondent. I have filed my statement of objection in that contest also.
Because this honorable court observed that go to the trial court and prove your title. That is why I have filed this case, and on that case only we have come before this court. And the matter before this court is on the very same, and the findings are very clear that he has to vacate and hand over the possession along with 1,000 rupees per month. This is a very old story. 120 in the High Court was a very old story. So after that, we have acted and filed a suit, and on that suit, we are before this court. They have come before appeal, it is allowed in our favor, and therefore they have come as appellants in this court, and we are respondents. The court is seized only of this matter. What has happened earlier does not come into the picture.
Yes,
May I go with the facts of the case?
1 minute. He has filed an IA for recovery of the alleged damages, mean profit. So it's only after disposing this at IA, I think we have to proceed on the main appeal.
But in that connection, the overall case is subjected with regarding to the main profit itself. I have filed my objection. There is no such jurial relation between me and the respondent. That is very clearly showed in HRC number, HRRP number 120 of 2008 that I have produced along with my statement of objection. May I take you to that page?
Suit is for possession.
Possession. They have
As a
claimed-
contained a jural relationship of landlord and tenant.
I'm not a tenant at all.
Has he taken the contention of tenancy in his suit?
He has taken my law.
Can you draw my attention to that particular pleading, please? And a relevant issue.
My lord, in the judgment, first issue itself, my lord, paragraph in OS number 27102.
What are the issues in this suit?
There are totally 5 issues, my lord. First issue is whether the plaintiff proves that as a owner of the suit scheduled property, he is entitled for the possession of the suit property. Second issue is, my lord, whether the plaintiff is entitled for the damage at the rate of rupees 500 per day. Third issue, my lord, whether the defendant proved that under the PA dated 5/6/2008, they have been possession of the suit scheduled property. Fourth issue, whether the plaintiff is entitled relief sounds. And with this, what is the duty of law?
Which among these issues speak about the jural relationship of landlord and tenant?
But with the same contents, one just my statement of objection. I'm not taking anywhere my. They are asking now. They are speaking about the possession. They never said I'm an illegal occupant also. They say everywhere that I'm a tenant. I'm not a tenant, my lord. I have purchased the property under a GPA, my lord.
If you insist that I have to be heard first, then it may take some time. We will hear the A and then go on the main matter.
One more submission also, my lord. In this case, lordship last time has said timingly paper book has been dismissed. Later, trial records are not available. If my lord permits, within 3 weeks, I'll file the necessary paper book also. I just need 3 weeks, I'll file the paper. But for timing, it has been disposed.
My submission is the arrears of main profits may be disposed of.
If I'm in arrears,
That is the judgment, that is the judgment. That is the judgment, that is the contention before this court. No use of talking about earlier, all observation. This case comes because of the 27-102 into Mayal court case on which they have come and appeal. That is the
Like counsel from both sides present. So the matter is shown in the final disposal list. The learned counsel for the applicant in IA 1/2022 submits that they said IA about the payment of mean profit be heard and disposed of first. Hence, we are registered to list the matter in the appropriate stage in the week of the next. Yes.
Final hearing matter. Appeal number 69. P.M. Siddhimalata.
Yes. Respondent counsel.
Bhaskar Babu, H.A.
Respondent. There is one.
Eriswamy. The Eriswamy, respondent.
Yes. Settlement. What is the difference?
Difference is that case may not, the thing dependent case may not. For security deposit is paying with the plaintiff
90,000.
90,000 is supposed to pay after deducting all the necessary charges. He himself is supposed to pay the rent.
On the previous day, probably the calculation, a rough calculation shown that
Yes, sir. Yes,
you were due by 1,70,000 rupees.
yes.
Then we'll proceed on the main matter.
Please.
Let him come, learned counsel for the appellant, who alone is physically present, submits that the settlement could not be arrived at between the parties, such as the appeal is required to be disposed on merit. The learned counsel for the respondent not present. List the matter in the next.
Serial number 70, Veena Kumari and
Because I appear on behalf of Veena Kumar. That is not. That is not.
But you are requested to address argument. Proceed.
The suit for specific performance of an alleged agreement to sell. The crux of the case is that the agreement itself, serious doubts are cast upon. Also, consequentially, the actual payment of the consideration, the time factor involved for specific performance, if the agreement is held to be valid. Suspicious. Primary aspect would be, my lord, that the plaintiff respondent claims that there was an agreement on 5/9/2012, and the stamp paper also is of that date.
Date of agreement is
Date of stamp paper is 5/9/12. Agreement is said to be 27/3/2013.
date of stamp paper is
5/9/12.
5/9/2012. Date of agreement is said to be
27/3/13. 2013. It's it at page 63 of the paper.
what is that document you are relying upon or referring to?
But the evidence of the plaintiff and plaintiff witnesses with regard to this document itself.
Page 63 which you are referring to is the evidence.
That is the stamp paper. The alleged agreement.
I go through the original document, therefore, rather than telling the page number in the paper book,
Exhibit
could you
P1.
tell me the
Exhibit P1.
yeah, exhibit P1. What are your main points of argument? You can elaborate them one after another.
This aspect is the agreement itself. As to when it was executed, what was the time period and such. Because there is a contradiction. The plaintiff, PW1 says that on 5/9/12 it's.
So you can elaborate the points of argument is
Yes, madam.
you disown the agreement. You have taken that plea in the written statement.
I have taken the plea.
Taken that plea.
I also point out my weaknesses with regard to that. On one side, I have denied it. On the other side, there is an admission to say that it is barred by limitation and such other. Therefore, to be very specific as your lordship wants me to be is a little difficult.
You can elaborate it. First say you make out the points of argument, and while elaborating on the each point of the argument, you can say add, supplement, delete, deviate.
When I make submissions, they may seem to be contradictory at the initial stage.
It may not be. Hope it will not.
That is one matter. The agreement itself, the consideration.
One is you disown the agreement. Second contention,
Consideration.
Because it is my specific intention that the property was worth about 50 lakhs of rupees, the market value at that time. I would not have entered into an agreement for 14 lakhs. That is the second aspect.
So are you suspecting the adequacy of consideration or sufficiency of consideration?
That also.
Whether adequacy of consideration can be a ground to avoid an agreement?
My lord, if one were to look into Nirmala Anand's case, it could be. Again, based on interpretation. I'm just placing my points before my lord. I'll elaborate as you said later.
Yes.
And then the question.
1 second. According to the property is worth about more than 50 lakhs at that time, but the sale consideration under the alleged agreement is 14 lakh.
This point would actually come first under the zoning of the document. Then as to Nirmala Anand's case will come at on the other side of the same.
Third point of argument.
The time factor. That is, he had to either get his refund or get the sale deed within 3 months. That has not been done. Even according to him, it was more than a year later that he has issued the notice in the first place.
Time factor. Any other points?
That I am ready to return the money with interest. So that's why I said some of these things might, on the face of it, appear contradictory. I straight away begin with the examination in chief of the PW1. Paragraph
PW1 could.
paragraph 3, my lord.
1 second. Yes, in examination chief, nothing much except the alleged agreement and the payment of advance amount of ₹10 lakh, issuing legal notice twice.
It's not just that. I read from paragraph 3 of this PW1 and show it as against the evidence of PW2 and 3.
Yes,
Now
please.
there are direct contradictions.
Who are PW 2 and 3 according to plaintiff?
According to PW2 is the broker who took him to the defendant who wanted to sell the property. And the PW3 is the advocate who is said to have drafted the agreement. At least see my lord, he says, I being the plaintiff approached the defendant, paragraph 3. Expressed my desire to purchase the plain schedule property. The defendant also agreed to the same. The negotiation consideration was fixed for 14 lakhs, being the value of the scheduled property on 5th September 2012. On the same day, the agreement of sale was drafted and typed. Thereafter, the defendant went to Bangalore. Since defendant and his family member are residing at Bangalore, and after consent of the defendant family members, the defendant came to after consent of the defendant family members, the defendant defendant came to KGF and executed and subscribed the signature to the agreement of sale on 27/3/2013 in my favor by receiving the part sale consideration of the sum of ₹10 lakhs from me as an advanced amount in the presence of the witnesses and agreed to receive the balance sale consideration of 4 lakhs within a period of 3 months from the date of execution of the agreement of sale. Yes. Wherein the defendant also put his signature for correction of the date in the agreement of sale. The original agreement is produced by me. I will stop with this and contrast it with the other two and then come back to this evidence for the next. PW2. Yes. Paragraph 2. I submit that Mr. Selvaraj, the defendant, approached me and expressed that he intended to dispose the property and want to settle at Bangalore and request me to get a good purchaser. Thereafter, I approached the plaintiff, who is running pawnbroker business in the suit schedule building, who is none other than the brother of so and so. He continued the business and expressed the willingness to purchase the same. I myself, being the mediator, along with plaintiff, approached the defendant and expressed the plaintiff's willingness to purchase to the marketable price. The negotiation was held in the house of the defendant. After negotiation was held, etc., the defendant agreed to sell for 14 lakhs. The plaintiff accepted the offer on 5th September 2012. On 27/3/13, the defendant acknowledged a sum of 10 lakhs as advance from the plaintiff in my presence and the son-in-law of the defendant by name Mr. Deepka, and agreed to receive the balance sale consideration of so and so before the office of the sub-registrar. Accordingly, myself, Mr. Deepka, plaintiff and defendant approached an advocate by name Mr. Mani G. The defendant expressed the entire transaction and request to execute an agreement of sale. The advocate verified the original sale deed belongs to defendant and drafted the agreement of sale and got it typed at the KGF court complex. The time is fixed for 3 months for registration. After that, the plaintiff and the defendants have signed, and thereafter myself and one so and so in the presence of the advocate. Thereafter, the advocate put his seal and signature. I can have the signature. According to him, it was not done on 5/9. The agreement is done on 27/3 in the court complex. How can we see my lord PW3?
According to broker, PW2, the agreement was executed on
27/3/13, not on 5/9.
Who has said that agreement was executed on 5/9?
He has said it was drafted, typed and prepared on 5/9, but then the date was changed later.
Date of execution, there is no discrepancy.
That is what they say. But kindly see here. He says that the document itself was not ready on 5/12, 5/9/12. It was done only on 27/3/12 by an advocate in the court complex. So it was not that it was ready on 5/9/12.
So which is material here?
What
Date of preparation of the document is material or date of execution is material?
It is material for this reason, that the time fixed was anyway 3 months.
Yes, 3 months from the date of execution.
Now, if it was ready on 5/9/12 and he went to Bangalore till March of the following year, 6 months later, he is still waiting to get permission from his family members to sign. And then suddenly he turns up in KGF and says, yes, today I will do it. It is not believable. And the initial burden is to prove he cannot rely on my weaknesses. And in this case, the weaknesses are plenty because the old man, he is unable to hear anything now. For everything you ask him, he'll shake his head for everything. In those days, he could hear a little, he's not as deaf as he is now. So those are not aspects, if I may submit, which should have been looked into and given so much attention to as what the plaintiff has said, because he should have first proved his case. Instead of that, the entire case depends on whatever weakness is there in the defendant side. Now kindly see PW3, my paragraph 1 itself. I know both the plaintiff and the defendant in the case. On 27th day of March 2013, the plaintiff and the defendant with 2 other persons have approached me with one Xerox copy of the registered sale deed and instructed me by the defendant to execute an agreement of sale in favor of the plaintiff in respect of the title deed property. The defendant explained me that the total sale consideration is so much, out of which he has paid so much. Now, it does not say that it was paid at the time of the agreement. The defendant is supposed to have told him, I have already received 10 lakhs. That again is a direct contradiction. So it's not at the time of preparation of the document or execution of the document. It is said to have been paid at some other time. The last sentence in that paragraph itself says, accordingly, I drafted of the sale to their satisfaction and dated type through the typist at the KGF Court complex on the same day. That is 27/3/2013. Because till that date, nobody had approached. Further, he says, I submit that period is fixed for 3 months from the date of execution of the sale agreement for registration of sale deed. I further submit. Then he said, after typing, I read over the contents to both, and after being satisfied, therefore, it was not ready on 5/9/12 according to him. So there is no question of correction of the date. So the document is shrouded in mystery, is my submission. And he says, after being satisfied of the contents of the agreement, plaintiff and defendant have signed before me each and every page. 2 witnesses also signed before me. Thereafter, I signed and sealed and handed over to the defendant, not to the plaintiff, but to the defendant. I can identify the signatures of plaintiff, defendant, witnesses, my signature. I collected professionally from the plaintiff through the defendant.
Stop here today and continue. Counsel from both sides present. The argument of counsel for the appellant in part. Consult from both sides present. The request of both sides. ಇಲ್ಲ ಅಲ್ವಾ ಐಎ ಯಾವುದಿಲ್ಲ ಅಲ್ವಾ ಅದೇ ರಿಕ್ವೆಸ್ಟ್ ಬೇಡ heard the argument of learned counsel for the appellant in part. Is further argument followed by the respondent's argument and reply if any. Is the matter wrong? 5, 6, 7 ಹೇಗಿದೆ ಡೇಟು ಅದು ಒಂದು ಮ್ಯಾಟರ್ 5ಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಆರ್ಮಿ ಹೌಸಿಂಗ್ ಇಂದು ಯಾವುದೋ ಒಂದು ಕೊಟ್ಟಿದ್ದೇವೆ ಡೇಟು 7ನೇ ತಾರೀಕು ಆಗ್ಬಹುದು ವಕೀಲ್ರೆ. 7/6 7 ಇದೆಯಾ ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರಾ? ಇವತ್ತಿನವರೆಗೆ ಇದ್ರೆ ಆಪರೇಷನ್ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಮಾಡುವ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡುವ. ಇಲ್ಲ ಇಟ್ರಿ ಮಾಡರ್ ಮುಂಚೆನೆ ಏನಾರು ಕೊಟ್ಟು ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ ಅಂತ ಇದ್ರೆ ಉಂಟು, ನೀವು ಎಂಜಾಯ್ ಮಾಡಿ. ನಂತರದಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಸೆವರಲ್ ಡೇಟ್ಸ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಇಂಟೀರಿಯರ್ ಮಾಡೋದ್ರ ಬಗ್ಗೆ ಏನು ಮೆನ್ಷನ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಆಮೇಲೆ ಜೋಡಿಸ್ಕೊಳ್ಳಿ.
Bill number 3, pass law matter, Adit Sushil Kumar Vikram.
Already.
Called again, learned counsel for the appellant who is physically present. Place for a time by a day. List this matter on 2/6. ಇದನ್ನ ಮೆಮೋದಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಹಾಕಿಸ್ಕೊಂಡ್ಬಂದಿಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ನೋಡ್ಕೊಂಡು ಹೋಗಿ ವಕಾಲತ್ತಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್ ಸಿಗ್ನೇಚರ್ ಸ್ವಲ್ಪ ಡಿಫರ್ ಆಗಿದೆ, ಸ್ವಲ್ಪ ಅಲ್ಲ ಕನ್ಸಿಡರಬಲಿ ಡಿಫರೆಂಟ್.